I was very excited when I found out that I was going to have the opportunity to speak about the Supreme Court of Canada's Figliola decision today, because I really, really, really like this decision. You may think it's a little bit strange for anyone, to be this passionate about a legal decision, but I just know that after hearing about it, many of you are going to rush out, get your own decision so that you can read it yourself, and then you'll all join me in saying that this decision warms my heart. As some of you may remember, about 4 years ago, the Ontario Human Rights Code went through significant amendments, including the addition of Section 45.1. And this provision allows the tribunal to dismiss a human rights application on a preliminary basis if its substance has been substantially and appropriately dealt with in another proceeding. So that seems simple enough if the issues now being raised before the tribunal have already been dealt with through the grievance arbitration process or under the Workplace Safety and Insurance Act, then the tribunal could or should dismiss the application. But the words appropriately dealt with created some confusion, and some wondered whether this meant that the tribunal could still hear the application to decide whether that other adjudicator had in fact appropriately handled the human rights issues. In other words, could the Human Rights Tribunal, in effect, judicially review or stand in appeal of another adjudicator's decision? You'll be happy to know that the Supreme Court of Canada answered that question with a resounding no. In Figliola, 3 injured workers filed appeals with the BC Workers' Compensation Board, arguing that its chronic pain policy was discriminatory. After hearing the workers' appeals, a review officer found that the policy was not discriminatory. Now, at this point, if the workers wanted to dispute the review officer's decision, they should have followed the appropriate statutory mechanism and sought to judicially review his decision. But they didn't do that. Instead, all 3 workers filed fresh applications with the Human Rights Tribunal, making the same allegations of discrimination that they had made before the BC Human Rights Tribunal, before the review officer. Now, the human rights statute in BC has a similar provision to Section 45.1 of the Ontario legislation, and relying on this provision, the BC Workers' Compensation Board argued that its review officer had handled all of the human rights issues, therefore the issues had been appropriately dealt with, and the tribunal should dismiss the complaints. The tribunal proceeded to review the substantive and procedural aspects of the review officer's decision and decided that the review officer had not appropriately dealt with the human rights issues. The Workers' Compensation Board judicially reviewed this decision, and the parties had alternating success on judicial review and appeal, and then they found themselves before the Supreme Court of Canada. The Supreme Court of Canada said that when deciding whether another adjudicator has appropriately dealt with a human rights issue, the tribunal should be guided by a number of principles. I've set out those principles in the paper, so I'd urge you to review them. But they include emphasizing the finality in decision-making, avoiding the relitigation of issues that have already been decided by another adjudicator, and respecting the appropriate appeal routes and judicial review mechanisms that the legislature has set. The Supreme Court of Canada also set out a 3-part test, which I've also set out in the paper, but it really boils down to asking the very simple, straightforward question: have the complainants had an opportunity to air their human rights issues before another decision maker that has the necessary jurisdiction? If so, then the human rights complaint ought to be dismissed because it has been appropriately dealt with. In light of this test, the Supreme Court of Canada did not have much difficulty finding that the review officer had in fact appropriately dealt with the human rights issues that had later been raised before the tribunal. The Supreme Court found that the tribunal's decision to proceed with the human rights complaints was improper for a number of reasons, including the fact that it substantially applied what classically would normally be a judicial review analysis, which was improper. It's obvious that the Supreme Court of Canada took a pretty dim view of what happened in Figliola. The court described the workers' actions as forum shopping, and this business of not showing respect for another adjudicator's lines of review was described as adjudicative poaching. Instead of referring the matter back to the tribunal in order for it to issue another decision consistent with all of the principles that the Supreme Court had set out, the Supreme Court said that there was no point in wasting any more of the parties' time and resources, and it dismissed the complaints. Given the identical language that exists in the BC and Ontario legislation, it's clear that Figliola applies directly in Ontario. Figliola is good news for employers because it confirms that an employer should not have to waste its time and resources relitigating issues before the tribunal that have already been decided by another decision maker. In light of Figliola, employers can expect informed employees to make strategic decisions on where to raise their human rights issues, because once they've raised them before another adjudicator, they should not be able to raise them again before the tribunal. Thank you.